Hubwonk. I'm Joe Selvaggi. Welcome to Hubwonk, a podcast of Pioneer Institute, a think tank in Boston. Dobbs versus Jackson Women's Health Organization is a pending U.S. Supreme Court case dealing with the constitutionality of a 2018 Mississippi state law that banned abortion operations after the first 15 weeks of pregnancy. This case represents the first serious challenge in nearly 50 years to the 1973 Roe versus Wade decision that determined a right to an abortion was constitutionally protected. By hearing this case, the court is considering whether Roe's precedent should continue to enshrine abortion as a constitutional right, or whether the historical context that existed before and since that decision suggests the court's findings were flawed. What is the history of abortion opinion and jurisprudence in America, and how might it influence the outcome of this extremely contentious case? My guest today is Ramesh Ponnuru, Senior Editor for National Review, a columnist for Bloomberg Opinion, and a visiting fellow at the American Enterprise Institute. Mr. Ponnuru is an historian who has focused much of his research on the history of abortion law, including his senior thesis at Princeton entitled Abortion in 19th Century America in Brief, and most recently in a National Review opinion piece entitled The Corruption of History. Mr. Ponnuru will share with us his views on the controversies over the historical underpinnings of the Roe versus Wade Supreme Court decision and reflect how these debates still serve to shape the arguments made in the recent Dobbs oral arguments. When I return, I'll be joined by writer, editor, columnist, and historian Ramesh Ponnuru. Okay, we're back. This is Hubwonk. I'm Joe Selvaggi, and I'm now joined by Ramesh Ponnuru. Welcome back to Hubwonk, Ramesh.
Thanks for having me back.
All right, before we get started, I want to let our listeners know that you and I are not going to settle the abortion debate today in the half hour we have together. Instead, I want to tap into your expertise as a historian, particularly an historian on the subject of abortion jurisprudence in the US, really from our founding to present day. Before we get into the details of abortion jurisprudence, how did you become interested in this topic? I understand you wrote a thesis as far back as your days back at Princeton.
That's right. So the question of the history of abortion law in the United States has played a much larger role than most people realize in the way the Supreme Court has handled the issue. And around the time I was in college, there was a set of briefs to the Supreme Court by signed by hundreds of American historians, urging the court to reaffirm Roe v. Wade and making a kind of historical argument for the decision. And so my senior thesis looked at that legal brief, which had been already pretty influential, and went through the sources and showed that the brief contradicted the sources that it was claiming to rely on and contradicted the published work of several of the scholars who had signed the brief. And this was a really kind of interesting kind of historical puzzle. But over the years, the influence of this false version of history, and as I'm suggesting, sometimes fraudulent version of history, has just continued to expand.
Now, this we don't want to impugn the integrity of our best historians, but one might assume that they may be using some sort of motivated reasoning. In other words, they want a particular outcome in the court, so they find the historical underpinnings to do that. But we all might be accused of being motivated reasoning or using motivated reasoning in our conclusions. If one were to sort of look for reasons for you arriving at the conclusions you had, clearly in your writing, you come out against Roe and perhaps the abortion issue itself. But is your historical analysis informed by some sort of personal preference or religious doctrine or religious belief?
Yeah, so let me try to take a couple of the interesting issues that you've raised and separate them. First, I think it's completely right to say that there's some motivated reasoning going on here, and I would divide the historians who signed these briefs into multiple categories. Some of them were not subject matter experts. I remember in particular, I've forgotten the name by now, but I remember looking at the CV of one of the signatories and finding that they're an authority on French colonial architecture in Southeast Asia. And, I'm sure they're pro-choice. And maybe some colleagues said show them this statement, and they assumed it was fine and it was for what they considered a good cause, so they signed it. I put in a different category the actual subject matter experts. Look, even some of their work, I do think, has some errors, and sometimes some interpretations that are unduly influenced by their policy commitments on abortion. But signing a brief where you're a subject matter expert and it just contradicts your own work, I think that falls into a different category. And that's a lot more problematic. As to my own reading of history, I have certainly my moral and my policy views about abortion and about other things. But the world is complicated, and history is never going to be a kind of neat story that where everything lines up in a predictable and kind of moralistically satisfying way. I'll give you one example of this. So one of the historical controversies that is at issue here is the role of American physicians and the fledgling American Medical Association in persuading Americans to tighten up the laws on abortion in the middle of the 19th century. And one of the arguments that gets made is that the doctors were really doing this for reasons of professional self-interest. They were unhappy about these irregular, unorganized doctors who were willing to perform abortions, and they wanted to suppress the competition. And I pointed out, and I've pointed out in several places, that this doesn't really make sense unless you assume that the doctors already had some other kind of opposition to abortion. Otherwise, they could have outcompeted these irregulars by performing them themselves, maybe getting a legal monopoly on performing them. And there's plenty of evidence that, in fact, A, the physicians themselves generally believed that abortion was a monstrous crime, and B, they only succeeded in persuading the public and the legislators by making that argument. The legislators weren't moved by an argument about the self-interest of these doctors. But here's what I think is kind of interesting, and I actually haven't had a chance to go into this in my recent writing on the subject. But the doctors, at the same time that they were campaigning for a stronger prohibition on abortion, were also arguing for the legalization of prostitution on public health grounds, and they didn't succeed. That argument just fell flat with the legislators and the public. And I just mentioned that because it's kind of a surprising thing, I think. I don't think that a lot of people would think of these as kind of twin causes, or be aware of the physicians having been involved in both of these campaigns at the same time. But it's a sort of a true and interesting feature of the historical record.
Sure. Now, just for our listeners' benefit, we are not talking about this historical analysis merely as an issue for academics to ponder. It has relevance, and it was actually, when we go back 48 years to the Roe decision, quite a bit of references were made to the history of abortion in America to support the decision of Roe, made by Justice Blackmun and others in the majority. So this is not merely you and I considering how things were in the past, but rather the court itself looking towards the past to inform its current day decision. What can you tell us about how this, let's say, alternative narrative was created? Where was Blackmun or other justices using as the sort of foundation for this notion of abortion as it was before Roe?
So there was a sort of self-consciously revisionist lawyer, law professor, historian, and activist for abortion in the 1960s, Cyril Means Jr., and he published two very influential articles making this counterintuitive argument that abortion had been a liberty at the time of the founding, and that when it was prohibited later, it wasn't because people believed that unborn children had a right to life, it was for other reasons. In his case, in the article that he was writing, it was because legislators were supposedly only concerned that these abortions were unsafe operations and potions for the pregnant women. And Blackman has an extensive historical discussion in Roe v. Wade, in which Means's scholarship is cited 6 times. Now, one interesting thing about this is that the successful legal team in Roe v. Wade, Jane Roe's legal team, which was sort of actually more interested in abortion activism than in adequately representing Norman McCorvey, it was well aware that Means was stretching and fudging the facts. There's an internal memo that has subsequently come to light where one of the junior associates says, this is not, this can't really be believed, but it might be worth doing if it works. And of course it did work. But what's interesting, one of the things that's happened since then is that these sort of false legal claims sort of have ping-ponged back and forth. So they come from the law review world with Cyril Means's work into the Supreme Court, and then they get cited. This gets cited as a kind of authoritative statement of history by subsequent scholars who cite sometimes Roe v. Wade. And then there are more legal briefs that are based on this false history. It becomes part of a series of books. So Lawrence Tribe and Ronald Dworkin both wrote big books on abortion in the 1990s, very prominent liberal legal theorists. They rely entirely on the fake history in their historical accounts of abortion. And specifically, they relied on that historian's brief that I was talking about that I had shown contradicted its own sources.
So I want to take apart, I don't know which way to go with this, but I want to take apart where Cyril Mean Jr.'s account of abortion jurisprudence in the past is inaccurate. You alluded to some of those features in your first answer. But how is it that one person, Cyril Mean Jr., is able to influence an entire court? And how is it that competing scholars might not be available to set the record straight? Again, I'll allow for the fact that this may be motivated reasoning, that the justices may have started with their conclusion and merely looked to the right answer or what they thought to be the right answer. But what is your version of that?
So let me maybe I should start by just giving it as simple an example as I can of the kind of, at best, really shoddy historical work that we're talking about in the case of Means. He cites one of the 18th century medical treatise writers and says that he's describing unborn children, the human embryo, as a monster. Well, if you look at that passage in context, what the author is saying, this 18th century author is saying, is that it doesn't look like what we're accustomed to human beings look like. He's talking about the form and appearance of the human embryo, but he goes on to say just a few pages later, obviously life starts, this embryo is a human life, and deliberately killing it would be a capital crime. So I think this is just one of many examples of sort of a clear distortion. It's maybe the easiest to grasp. As for why it was so influential, I think that all the sort of the best and the brightest in the late 1960s were moving in a pro-abortion direction. This seemed to be kind of the wave of the future. The courts had been sort of liberal and progressive for quite a long time. This all sort of dovetailed with what they wanted to believe. And the opposition was just seen as some kind of crankish, hidebound Catholics, and people who would be sort of swept away by history in short order. It didn't work out that way ultimately, but you can see in the way Roe is worded and the way it's received that there was this expectation that we don't really need to listen to another side of this argument. They're dinosaurs. They're going to disappear. So in the New York Times front page story, the day after Roe is issued, the Times says it's a historic resolution of this issue. That is, this argument is now over.
Right, it's been decided. And in fact, we talk about, you mentioned in your piece that the historical underpinnings of Roe were starting to crumble even as Roe was being decided. And yet there's a later case, it happened 1989, 16 years later, Webster versus Reproductive Health Services, where they characterize abortion as a common law liberty at the time of the founding. How, again, does in a sense, a controversial issue that was historically controversial and theoretically settled by Roe, how did that suddenly become a common law liberty?
So by then, by 1989, of course, this is a sort of a raging controversy, and it's pretty clear that the pro-life side of this argument is not just going to meekly disappear, and it is considered by the supporters of Roe v. Wade very important that they get the historical profession, as much of it as possible, on record, using their expert authority to strengthen this case. Now, they're stuck with Roe v. Wade's argument about abortion being a common law liberty. And, some of them believe some version of it. And so they seek to bolster it. And they do it by finding anything in the historical record that could possibly support it. So, for example, they're trying to make the case that at the time of the founding, abortion is not only supposedly a liberty, but is also commonplace. And they find another writer who says, very often abortion is no fault of the mother. It's entirely blameless. Again, you go to the actual source, and it becomes clear he's referring to miscarriages, which are still to this day sometimes called spontaneous abortions. And the author is, in fact, a very ferocious opponent of deliberately causing an abortion, using the term the way we would use it today. That goes into the legal brief as nobody minds abortion in the 18th century. They go on to distort the record of the physicians. One interesting thing is there's a lot of, to the extent 19th century feminists took up the question of abortion, they were opposed. And the brief really kind of insinuates that they were supporters of abortion. And you have to be reading it very carefully to see they're not actually saying that, and they don't actually prove it, because it's the exact opposite of the truth.
So I want to analyze, again, we're talking about how the history regarded abortion. And you have made the case that at least the argument in modern times has been the only person who would outlaw or oppose abortion are people who may be concerned about, or the people who support abortion were largely concerned about the welfare of the mother, and that there really was no regard for any inherent right of the unborn child, and therefore, what follows then is this regard, giving constitutional rights to unborn children is a relatively modern phenomena. Why is this aspect of the argument so important? Why is sort of ignoring the fetus, or whatever word we want to use on the show, why is that an important distortion?
Well, the Supreme Court, I think it serves both a legal and a political purpose. So the legal purpose is that the Supreme Court has developed a body of law that says that it should provide constitutional protection to those aspects of liberty that are kind of deeply rooted. The phrase is deeply rooted in America's history and tradition. And so this is an argument that abortion is deeply rooted in America's history and tradition, which is a phraseology, by the way, that was just about verbatim used by the advocates for abortion in the oral argument in the Supreme Court last week. But the political purpose is also just to say it's a twofold one. It's first to say, abortion is tradition. Roe v. Wade isn't a radical or revolutionary decision. It's the restoration of an old tradition. And then it's to discredit the opponents. The idea is there was never any real belief in unborn human life. There were a bunch of professional self-interest. There was sexism. There was racism, and so some of these liberal historical documents, like the brief in Webster, sort of insinuate again that's still what motivates opponents of abortion. They're not really concerned about unborn human life. It's that they have the same racist and sexist motivations that they did back in the 19th century, but they've gotten better at hiding them.
So let's explore again. I would think one of the most persuasive artifacts of the history of abortion would be laws on the books that forbid it. Again, going back to our founding, you make a reference to mid-19th century. By the time the 14th Amendment was passed, we had 37 states, I believe, and 30 of them had laws against abortion. Say more about what those laws look like. How criminalized was the practice?
Yeah.
To me, that would be very persuasive that our founding fathers held it in low regard.
Right. So abortion had been for centuries illegal at common law, but it wasn't until 1827, if I recall, that the mammalian ovum was discovered. And there's a lot of kind of folk biology dating back to Aristotle, where people weren't sure when you had a human life, just in the sense of, you have a human organism that's alive. And so early in pregnancy, there was this question of, did a crime take place if there was an abortion? How will we prove that that happened? Now, it was never considered a right. It was always clear that even early in pregnancy, the attempt to provide an abortion was unlawful, that there are various things you could do to discourage it. Contracts to perform abortions, again, even early in pregnancy, were void because they were for unlawful purpose. But there was this problem of how do you prosecute? And actually, that's one of the ambiguities in the historical record that ends up getting exploited to create this myth of abortion as liberty. But as scientific understanding is growing in the middle of the 19th century, there becomes this campaign, again, physician-led, to say that abortion should be, by statute, made a criminal offense at every stage of pregnancy. And so that's by 1868, the time of the ratification of the 14th Amendment, a supermajority of states have tightened the law because it was seen as sort of what we were already trying to do, but now updated in light of scientific advances.
Now, the laws were on the books. Forgive me for this, this odd question, but were people, doctors or mothers or anyone actually prosecuted with these laws, or is this sort of a way to discourage or dissuade people without locking them up?
Well, it depends on the time period you're talking about. So we have records of cases of prosecutions for abortion in England back to the 13th century, in what was then colonial America back to the mid 17th century. Not tons of them. Partly it's just records from those times can be hard to find, but partly I think Joseph Delapenna, in his extremely long and exhaustive history of abortion in Anglo-America, comes to the conclusion that abortion just wasn't very common for many, many centuries, and really until the last few hundred years, because the methods of abortion that were known and available for almost all of our history either didn't work, didn't actually kill the baby, or were extremely dangerous to the mother, or both. And so it's not really until the 19th century that you start having a significant number of abortions and then a significant number of prosecutions. The prosecutions that, there were a lot of the time, the prosecutions were there to sort of make a point, for their kind of exemplary effect. That's one of the reasons, by the way, that these laws, either explicitly or in practice, rarely held the pregnant woman to account for procuring the abortion. I mean, sometimes you need her testimony in order to do what the law considered more important, which was to stop the abortionist.
I see. So let's zoom forward with the time we have left and talk more about modern times and its reliance on the past. I sat through the 2 hours of oral arguments as a layperson. I'm not an attorney, so some of it seemed a bit legalese. But what struck me was, after I listened to the arguments after having read your piece, listening carefully for some reference to earlier jurisprudence, essentially the underpinnings of Roe. And I think it was the closest I came to hearing anything was when Justice Alito asked those trying to strike down the Mississippi law about, give me your best case, meaning your precedents before Roe that indicates that this is a long tradition, that the precedent even predates Roe, and the attorney could not come up with anything. Explain for us the importance and significance of that.
Yeah, that was a very interesting exchange. Justice Alito tends to do his homework, and I think the questions that he asked evinced a familiarity with this historical dispute. And he was asking Julie Rickleman, the lawyer for the Jackson abortion clinic, involved in this case. And you're exactly right, he had this line of inquiry about the history of abortion law. Rickleman keeps answering with this basically mythological version of that history, and says that it was recognized as a liberty. And Alito, I think, pretty clearly meaning, okay, cite me a court case from this time that recognizes abortion as a liberty. Says, what's your best case? And she, either misunderstanding the question or unable to come up with a good case, instead treats the question as though it had been, what's the best case for abortion rights in the Constitution? And she then sort of retreats into a boilerplate answer.
Right. So in other words, when he meant not make your case for abortion, but rather cite me a case that establishes the right to abortion before Roe. In either case, she did not answer the question. So we're getting close to the end of our time together. I want to wrap up with this whole notion of, principle of stare decisis, that precedent prevails, and that we've got a precedent of Roe of 48 years, good or bad. It's called the reliance doctrine, which is people live their lives now expecting safe and reliable access to abortion. Is there any foundation or any sort of thing within the context of stare decisis that prohibits the court from genuinely considering this issue? Is it an inviolable principle now that it's 48 years old, or is it still as open to debate as it was 48 years ago?
Yeah, I mean, this is obviously an intensely debated subject, and part of the intensity of it is that everybody understands really that that you can't give it total deference, right? You have to be able at some point to overturn erroneous Supreme Court decisions. And this was another exchange that was really difficult for the advocates of abortion who were at the Supreme Court, because they want to make such a sort of a fetish out of never overruling precedent. They end up getting tripped up over things like, well, then was Brown v. Board of Education, which overturned a more than 50-year-old precedent, Plessy v. Ferguson, How do you justify that? And would it have been wrong to overturn it, 2 years after it had been issued? And they were really kind of tripping over themselves and not able to give an answer. I mean, I think the truth of the matter is pretty obviously that a decision of the Supreme Court can be so erroneous that it demands to be overruled, regardless of the passage of time.
So I want to close by again appealing to your knowledge as a historian and say, okay, let's imagine with the Dobbs case, in the worst case scenario for pro-choice advocates, Roe is overturned, and essentially we take the issue of abortion out of the Supreme Court, and return it to the states and state legislatures. As a historian, is this handling of the issue of abortion more or less consistent, again, if Roe is overturned, with our historical, again, going back to Aristotle, going back, how has abortion been managed and looked at in the past? And is a pre-Roe or post-Roe world more consistent with that view?
For most of US history, abortion was prohibited with various degrees of stringency, and legislatures in each individual state led the way. Roe v. Wade interrupted that history by summarily declaring the laws of all 50 states, from the most conservative to the most liberal, null and void. And if we were to undo Roe v. Wade, to overrule it, we would return, I think, to the kind of situation that is what the founders intended, which is that even on intensely divisive questions, it's the people and their elected representatives who make the law, and not 9 robed individuals sitting in Washington, D.C.
So those of us sitting here in Boston probably won't see a very, very different world, but other states with other priorities and other preferences might.
Yes, that's right. I think you will find that the laws of the states are going to more accurately reflect the sentiments of the people in that state, which doesn't mean there's an end to this debate, but it means the debate, I think, takes maybe a more constructive form, and at any rate, a form that is more in keeping with our Constitution.
Indeed. I'd say I don't think it's the end of the debate. I think it's the start of the debate, having it had been ended for 48 years, right? Well, thank you very much, Ramesh. This has been a very interesting conversation, and I don't think we, as I promised, we didn't settle the issue of whether abortion is a good idea, but rather we said, what is its legal history, which is what I wanted to get to. So thank you very much for sharing your knowledge and wisdom with us today on Hubwonk.
You're welcome.
This has been another episode of Hubwonk, a podcast of Pioneer Institute, a think tank in Boston. If you enjoyed today's episode, there are several ways to support the show. It would be easier for you and better for us if you subscribe to Hubwonk on your iTunes podcatcher. If you'd like to help make it easier for others to find Hubwonk, it would be great if you offer a 5-star rating or a favorable review. If you have ideas or comments or suggestions for me for future episode topics, it would be welcome if you email me at hubwonk@pioneerinstitute.org. Please join me next week for another episode of Hubwonk.